Analysis for 29th of January 2025. So in today's news analysis, guys, we are going to talk about these important news articles for the day: denotified tribes, then the Supreme Court judgment on SC/ST Prevention of Atrocities Act, right? So these issues, I'm sure voice and everything is taken care of. Yeah, so it's working fine. Denotified tribes, and then SC/ST Prevention of Atrocities Act, then Annual Survey of Education report, the much awaited report for we, the UPSC aspirants. We look up to it by the Pratham NGO. This report every year, every 2 years, is released with the data on what is the survey, what is the status of school children, what is the status of education at the school level in India. So these things we are going to talk about. Just allow me a moment. This doesn't seem to be working. Yeah, remote is working now. So this is the Telegram channel. You can subscribe to this Telegram channel in order to get regular updates about my other classes and hell lot of activities on PW Only IS English channel, be it current affairs, be it your current affairs MCQs, etc. Then mains questions that I'm posting on the Telegram channel, and every morning to get the live updates about this lecture, its PDF. This is the way to go. The Telegram channel, you can subscribe for all the updates. Now these are the news articles, 7 news articles to be covered. Some of them are highly analytical, conceptual in nature, like peer-to-peer lending. This I'm sure would be new to you. Many of you must not be knowing about what is peer-to-peer lending, and this is platform based lending. So this is the article that we are going to deal from economy section for today. Then we are going to talk about what's on the agenda of Paris AI Summit, where PM Modi is the co-chair along with the France President Emmanuel Macron. Now, then the Supreme Court says that the serving of notices by the courts should not be considered valid if the court notice summons by the court are being served by the concerned police station with the help of WhatsApp. So service of summons has to be done via registered post or speed post, but it cannot be held to be valid. The person will not be considered as having been summoned if the summons are served through WhatsApp. Very easy news article, I mean factual only, but this tells you about how the court procedures happen, right? If you guys have any doubt whatsoever, you can post it in the comment section of this YouTube community post. Then today onwards, we have incorporated the questions just after the topic so that the enthusiasm, the curiosity that you have is maintained and you attempt the question right there instead of postponing it to the last leg of our lecture. Now let's get started. Apart from this, there are other articles also. Now see, one of the founding members of the Infosys has been booked under SC/ST Prevention of Atrocities Act 1989. What do we mean by this act? Why has he been booked for a crime allegedly done in 2014? First thing first, SC/ST Prevention of Atrocities Act says that any member of non-SC, non-ST community, if he meets out, if he tries to humiliate any member of SC/ST community, then that person, like in the picture here, will be booked under SC/ST Atrocities Act. Atrocities means, just to give you an example, if somebody is calling or addressing the member of SC community in a derogatory manner, right? Some derogatory terms which you are quite aware, being a part of this Indian society, we are still carrying that baggage of Verma system, right? So if those derogatory terms are used to humiliate people from belonging to SC/ST community, then person could be booked under SC/ST Act. Okay, now these laws are considered to be positive laws or affirmative laws for the upliftment of the erstwhile or the upliftment of the people who were in the past subject to this kind of victimization, women included, SCs, STs included, right? So calling them Harijans, calling them with due respect to all the members of SC/ST community, calling them with the names which should not be done in a civilized society. Okay, so those things are happening even today also. So that is why, to address these kind of problems, SC/ST Prevention of Atrocities Act was brought about. Now there is no time freeze. That means in the matters of ordinary law, there is a term called as time freeze. That means from the date of happening of crime, within 3 years, if you do not report the crime, that means the crime did not happen. But in case of affirmative laws like SC/ST Prevention of Atrocities Act, there is no time freeze. In Dowry Prohibition Act, in Domestic Violence Act, these laws are in a manner, they are so framed like Vishaka guidelines. As per Vishaka guidelines, uh, Protection of Women from Sexual Harassment at Workplace Act 2013 was enacted. In that also, if a woman reports a crime which happened way in the back date, okay, I mean way backwards, like in this case the act actually happened in 2014, but the crime is being reported in 2024. A teacher, a person who reached out to the IIS, this body where the former CEO, I mean the founding member of the Infosys was working as the consultant member or in whatever capacity, this person subjected the member of an SC community to humiliation. Okay, the complainant belongs to Bovi community, scheduled caste. He was a faculty member at the Center for Sustainable Technology at IIS, Indian Institute of Science. So this person being associated with IIS in the management capacity, he victimized person belonging to SC community way back in 2014. Okay, for that crime also, this person has been booked in 2024. Right. Now, what are the other provisions? You got my point? There is no time freeze in these type of laws. First thing first. Background, we will go to the background also. What happened in 2018 when Supreme Court diluted certain provisions of the Act? What were those provisions? Provision number 1, there is a provision of automatic arrest, that when the member of SC/ST community goes to the police station and files a complaint, okay, in ordinary laws, what happens? A preliminary inquiry, a rough diary noting is done by the investigating officer, who happens to be sub-inspector in the police, or in petty crimes, he could be head constable in police. Okay, majorly it is done by the additional sub-inspector level officer. He goes to the scene of the crime, or he goes to the complainant, notes down the facts of the case, and then he counter questions or he questions the complainant and the accused. But in case of SC/ST Prevention of Atrocities Act, there is automatic arrest. There is no such preliminary inquiry to be conducted. Got it? Because of which, sometimes the members hailing from general category, to just distinguish it from the SC/ST category, members hailing from non-SC/ST community, they stand to lose out in the society. They sometimes are victimized unnecessarily. On the pretext of the false complaint, if somebody is arrested, they are immediately suspended or dismissed from the government job. Right? If the complaint happens to be false, it appears that the complaint is false at a later stage when the complainant is questioned by the district magistrate, the judicial magistrate, when the investigation is done. Afterwards, the damage is already done to the character, to the life of the accused. Accused is not convict, but subjecting him to jailing, arresting him directly, sometimes does the irreparable damage to the life of the accused. So that is why Supreme Court in 2018 had diluted this law, SC/ST Prevention of Atrocities Act, to the effect that there will be no automatic arrest. Got it? That means right after the complaint, police will not immediately arrest the person before conducting a preliminary inquiry. Our preliminary inquiry is before lodging an FIR. In the rough diary, what we call as in Hindi kachi diary, right? Diary noting, or police personnel, he comes with a piece of paper and jots down the facts of the case as explained to him by the victim and the accused, both the sides. Hearing both the sides, application of police mind, and then registration of the case, then arresting the person. This is the ordinary course of justice, because principles of natural justice, they say that nobody should be condemned unheard. Nobody should be condemned unheard. But in this case, since the physical balance of law has to tilt in favor of the already victimized, already persecuted, Those people are SC, STs, women. So in these laws, there is a provision of automatic arrest of husband in case of Domestic Violence Act, Dowry Prohibition Act, or the family of the husband. So in Supreme Court, Justice UU Lalit, I remember the name correctly while I was preparing, writing my mains and all, 2017, in July 2017, the judgment related to women was also diluted. This is a topic of GS Mains Paper 1, social issues. Okay, that time Supreme Court said that on the basis of the complaint filed by a woman against her husband or her in-laws should not be automatically leading to the arrest of the husband and his family, because husband might stand to lose out on his job. The prestige of the family, the social stature of the family might get tarnished for ages, that they were arrested on the pretext of a complaint, which later on might turn out to be a false complaint. But that judgment and this judgment, SC/ST Prevention of Atrocities Act, which stood diluted by the court to the effect that there will be no automatic arrest, were later on restored back to their original glory to the effect that now automatic arrest will be there. Then what is the safeguard institutionalized by the Supreme Court? What safeguard has the Supreme Court inserted in this? Supreme Court has now said, after that 2018, that an officer not below the rank of Deputy Superintendent of Police should be investigating it or should be lodging the complaint. That means sub-inspector level or junior officials shall not be going for arresting the person, shall not be the ones registering the complaint. Okay, so see here the hierarchy. Here we have head constable, then you have SI, then ASI, additional sub-inspector, etc. Then we have inspector or SHO, we colloquially call him, right? Inspector. Then we have above 3-4 inspectors, we have a DSP, Deputy Superintendent of Police, who is the head of 3 or 4 or maybe 5 police stations, all the police stations at the city level, tehsil level. Then above DSP, it is SSP or ASP, right? Then above 4 ASPs, it is Senior Superintendent of Police. Now, under the SC/ST Atrocities Act, complaint will be registered by an official not below the rank of DSP. Point taken, understood everybody? So this is the protection now. Now, another point is there is no compounding of offense in the SC/ST Prevention of Atrocities Act. What do we mean by compounding? Compounding means compromise. In simple language, it is called compromise. In the Dowry Prohibition Act, in the rape, in the matters of rape, in the matters of juvenile justice, in the matters of POCSO Act, Protection of Children from Sexual Offences Act, all these laws, my dear students, are called affirmative action, affirmative laws, protective laws, positive laws for the upliftment of the sections of the society who were subjected to persecution, victimization in the history of India. Okay, so for these laws, there is no compromise, because one of the sides, that is the complainant, accused is already in the position of power. Like this person happens to be the founder of Infosys, and against him is a complainant who happens to be the member of scheduled caste, with due respect. So what is happening here? One person, the physical balance of nature, I mean the practical side of the justice needs to be seen, that one person is already influential, power of money, etc. is in his favor. So he will be able to bribe, he might be able to bribe the police officials, and police officials will say that matter has been compromised. And sometimes police personnel, they put undue pressure on the victim to strike a compromise. Take 2 lakh rupees and keep your mouth shut. Else police people sometimes say that we will victimize your family, or we will drag you to courts for in other matters. So that is why compounding or compromise in these cases of SC/ST Act, of Dowry Prohibition Act, Domestic Violence Act is not allowed. Clear? So I'm telling you the whole crux of certain, the common thread between these affirmative laws. I'm trying to connect so that whenever you come across these matters, you are able to know compounding is available in Dowry Prohibition Act, Domestic Violation Act. No, compounding is not allowed, because women would be then pressurized by the police to withdraw the complaint against her husband in case of Domestic Violence Act. So these things are there, right? Now, salient provisions of the act. This act does not apply to crimes committed between SCs. And now what happens is, the lacuna in the act is that this act considers the people from non-SC. I'm using the word general very cautiously with due respect to the SC, ST. Okay, then there is SC category 1. Let's say these are of higher caste. Okay, and these are of lower caste SC. Within SCs also, there is no homogeneous category. SC is not a single circle. There are very many small circles within circles. Okay, so if one dominant scheduled caste persecutes or victimizes an other relatively lesser dominant or less powerful scheduled caste, then this act does not apply. Okay, if there is a crime between SC and ST or ST and SC, then also the law is silent on that. If there is a crime between SC, SC inter se, between the members of SC community themselves, I mean, then also this law does not apply. Got my point? So this is the lacuna in the law, that one member of scheduled caste who happens to be from higher caste, relatively high caste, then this happens to be relatively from low caste. If the crime is committed by higher caste against the lower caste SC, then also the law is silent. Clear? Clear? These type of questions are being asked in prelims, especially after the 2018 judgment, which led to the detailed analysis of this issue or highlighting of this issue in the news affairs, current affairs. Okay, there are 37 offences included in the act that involve patterns of behavior inflicting criminal offences and breaking the self-respect and esteem of SCs just because they are SCs. Why am I saying just because they are scheduled caste? In August 2024, another judgment of the Supreme Court had come. You see this judgment, I have incorporated the clipping. Not every insult against scheduled caste, scheduled tribe persons can be considered as an offence under scheduled caste, scheduled tribe protection law. What happened in this case? A member of parliament who belonged to scheduled caste category from Kerala had filed a complaint against a YouTuber news portal like me. You can say better than me, right? I mean, in the sense that he was having more followers. We are in Kalyug, so having more followers and more views corroborates to having more knowledge and more senses. Now, coming back, so what happens? YouTuber had lodged or YouTuber had uploaded some defamatory video against that member of parliament because of some corrupt practice. Okay, but this news analysis is in English completely. So for Hindi, you can watch the other channels of PW Only IS English. So this person is an MP. Okay, MP indulging in corrupt practices. Okay, corrupt. This person is a YouTuber. Okay, running his channel YT YouTube. This person had uploaded some derogatory video against the corrupt practices of member of parliament who happened to be belonging to the scheduled category. This member of parliament dragged him to court, alleging that just because he is the member of scheduled caste category, this YouTuber who happens to be from general category is defaming him. Got it? That means the application of law was being far-fetched. Okay, it was being stretched too much. Now, the Supreme Court in August 2024 clarified that not every insult against the person, SC/ST person, shall be considered as an offence under SC/ST Protection Act 1989. What is Supreme Court saying? Bench says law only applies if the humiliation, insult inflicted by the aggressor is intricately related to that person being scheduled caste. If the insult is being related to corrupt practices of an MP, how can MP drag the aggressor, alleged accused, just because he member of parliament belongs to the scheduled caste? Getting my point? If the accused is inflicting some humiliation because of the corruption of an MP, MP cannot go to the court or police station and say that MP is a scheduled caste and that is why he is being victimized. No, right? Belonging to SC and ST does not mean that for every allegation against you, against the SC ST person, that person will drag the other members of the community or society just because he is a member of scheduled caste community. Got it? So these are social issues. You got an idea how they are to be studied. While making notes, what are you supposed to do? All these type of judgments you are supposed to extract. Divide your notebook into 4 parts. Let's say GS mains paper 1, social issues, women, gender empowerment. Then the victimized, the disadvantaged sections of society. This way you can extract these notes, the judgments. Over a period of time, you will see a very beautifully organized judgments of Supreme Court all at one place with regard to SC/ST Act. Okay, this judgment was of 2024. So anybody who is preparing for 2025 prelims would have or should have made the notes on this judgment. Then this judgment is coming. You get to know some more sections, etc. Make a note out of those sections, out of those news issues which appear maybe days apart, months apart, weeks apart, right? This way you will have everything handy and you will be able to have a coherent answer. You'll be able to have a well organized answer, and all the repository of information, knowledge required about a particular topic can be extracted from news issues. And the best part of reading the newspaper every day is that you collect everything not only in the notebooks but in your memory also, because you know the text, you know the context. You can attach the image of person who is being victimized, if not the image, at least the Infosys CEO, former founding member. This very title will help you recollect the entire case. Got it? And this is how you recollect in the examination and are able to produce. So all the strings of judgments related to a particular topic need to be jotted down at one place, and that can happen only when you organize your notes or divide your notebook in a section based manner. Disability Act, transgenders, then LGBT community. So GS mains paper 1, one notebook divided into 4 or 5 sections having 25 to 30 pages each. So this way all the judgments related to SCs, STs, women, disabled people, transgenders, street vendors community, all these topics can be had at one place. And whenever some news appears with regard to one or the other topic, that news extract only should be jotted down in your notebook for future reference for revision. Now, section 4 here, as it is mentioned, it deals with the punishment for neglected duties. Now see here, as I said, there is no provision for compounding of offense under SC/ST Act, SC/ST Prevention of Atrocities Act. Okay, so if any police officer exercises some delay or avoids the filing of FIR, avoids the registration of complaint by the member of SC/ST community, that police officer, even if maybe SSP, SP, anybody for that matter, would be charged with dereliction of duty. What do we mean by dereliction of duty? Not performing your duty as per the requirement. So dereliction of duty, negligence, it will be counted. Okay, he could be suspended for that. His promotion could be withheld. Likewise, his increment, annual increment could be withheld. Those type of things can happen. Okay, ordinarily the arrest under SC/ST Prevention of Atrocities Act is 6 months, and it could go up to 5 years depending upon the gravity of the crime. Now, we are in the digital age, we are in the age of WhatsApp, Telegram, Signal, etc. Now, what is happening is, to hasten the judicial process, police people are serving the notice. If somebody commits the crime, okay, if somebody commits the crime, then court sends the notice. Court sends the notice to the person to appear in the court. But what happens is, the notice is supposed to be delivered to the letter box or to the correspondence address of the person, okay, as per the requirement of section 41A of CRPC or section 35. Now you should remember section 35 of Bharatiya Nyaya Sanhita, okay, the new code that we have had. This envelope needs to be sent to the registered address. Any order given by the court summoning the person to appear before the court. should be sent to the registered address, let's say 420, house number 420, anything for that matter. Okay, this needs to be sent. But what is happening is, to this person, the notice or summons are being sent on the mobile phone of the person, thereby not paying due regard to Section 35 of Bharatiya Nyaya Sanhita, the Indian Penal Code, the new code that has come into operation. Okay, so WhatsApp or other electronic mode should not be considered valid. This is what the Supreme Court has said in a case in which the senior advocate had appeared as amicus curiae. What is the meaning of amicus curiae? CURAE. Amicus curiae is appointed by the courts, be it a High Court or a Supreme Court, to guide the court. Please write it down if quickly. To guide the court in the matters where the court feels that it is not having enough knowledge, enough field knowledge about the matter. Friend of the court is another word for amicus curiae. Okay, so anybody who is an expert in the matter of water management, hydrological dams, etc., okay, can be appointed by the Supreme Court to advise the Supreme Court on the matters whether dams like Tihri Dam, Tista 3 Dam in Sikkim, whether that dam could do ecological damage or not. Okay, helper of the court or friend of the court, appointed by the court to enlighten the court on the matters before it. So since this matter was there before the court, amicus curiae, the senior advocate who had enough knowledge about the matter, was appointed as the amicus curiae. He suggested court that serving of notices through WhatsApp, etc., is leading to travesty of justice, is leading to notices being not served, and people to whom notices were being served being victimized. That notice has already been served. Okay, ordinarily the court sends the notice through India Post, registered. It has to be a registered post. But my point is counterpoint. Don't you think that in the era of Gmail, etc., in the era of telecasting live proceedings of high courts, whereby certain judges are attracting a lot of fame by getting their videos or shorts uploaded, like Tina Dhabi, okay, on the YouTube, etc., and then there is another IAS officer, Deepak Rawat sir, right? They are quite social celebrities in their own light, because they are hogging all the limelight. Okay, and this is something against the civil services rules as well. You see so many IAS, IPS officers, the candidates, once they get selected, they are all over the social media, their social accounts, etc. But once they are into service, they go into oblivion, they go into silent mode. Why? Because civil services rules do not allow these things. Similarly, when the court proceedings are being telecast live, don't you think that we should have a system where India Post registered ID should be there for people having a certain threshold of income? If somebody is earning 10 lakh rupees in this digital age, can we say that he would not be a tech savvy person? Yes, we can say that, but the likelihood is very low of such persons being totally technologically ignorant. So having India Post registered email ID for people who are paying tax, etc., or Aadhaar linked email or Gmail ID should be there, and WhatsApp, etc., because should be allowed to be used, because this will help us fast pace the judicial processes. Serving of notice via speed post or registered post takes 20 days if the letter is supposed to come from South India to North India, 15 days at times. So this is leading to drain on the wealth of the courts, income of the courts also. WhatsApp notice, if served on the registered mobile number, should be considered to be valid. However, Honorable Supreme Court has said to the contrary. Let's move further. Now, another important thing that has happened here is the bench further directed High Court committees. Now, what has happened is, under the Chief Justice of High Courts, all the High Courts in fact, there are committees, respective committees, to deliberate upon the judgments of the Supreme Court. What happens is, Supreme Court gives a judgment. The problem with that judgment is that judgment does not percolate down to the district level judges. Okay, percolation means that judgment is not even known to the police people or police authorities or district judges, because once you get selected, you don't read the newspaper. Okay, training does not happen. So that is why across all the high courts, committees are constituted to ensure that both the past judgments of the Supreme Court and the present decisions of the court are made aware to the high court judges, and then regular meetings and training should happen. For example, recently Supreme Court said that section 66A of IT Act, it has been struck down by the Supreme Court way back in 2013, is still not known to many SHO level officers, police level officers at the lower rungs. Why? Because the judgments are not percolating downwards. They are not reaching the ground level where they are to be implemented. So that is why regular respective committee meetings are to be held on a monthly basis, so that Supreme Court judgments, etc., the orders, the directives are known to all the High Court judges, and they are implemented in the right manner as required by the court. Now coming to another important issue, social issues, GS mains paper 1. The Anthropological Survey of India and the Tribal Research Institution across the country have for the first time comprehensively categorized 268 denotified, semi-nomadic and nomadic tribes. One by one, these three terms quickly explained. What do we mean by denotified tribes? In the British era, how many of you have seen the movie Milkha Singh, right? Then Delhi Crimes 2. What happened is, in the British era, there was a certain set of tribes, with due respect, they were habitual offenders. In Milkha Singh movie, you see Milkha Singh himself stealing coal or grains from the moving train. Whenever the train used to pass a particular stretch of the track, okay, so there would be certain tribal communities living in the shanties or jhuggi jhopadis, okay, hutments, etc. They will loot the train wagons when the train passes from a particular stretch. That is why when across these stretches, there would be extra railway personnel, police force deployed in the British era also, so that these trains are not looted. The grains, the coal, etc., that is being transported via train is not looted by these tribes. Because of their habitual offending nature, I mean, because of their very nature that they are habitual offenders, they were notified in the act. Which act it is? Notification means like UPSC notification comes, they were notified in the schedule of the act that they are now notified for being a habitual offender. The Criminal Tribes Act of 1871. Got it? So this is the act, Criminal Tribes Act. So this act was whenever some tribe, members of tribe were found to be habitual offenders. Milkha Singh would be caught, somebody, with due respect to the people, right? So somebody or the other would be caught from those areas. The whole village or the whole tribal community would be labeled as notified, would be notified as criminal, habitual criminals. And Britishers would keep a strict watch on them. If any crime would happen, members of that tribal community would be haunted. They would be dragged to police station and they would be given third-degree torture. Confess that you have committed a crime. Okay. Now, certain sections around South Patel Nagar, Delhi, Patel Nagar area, okay, there these community members of these communities in Pandav Nagar, etc., with due respect to all the sections of society living there, my endeavor is to tell you why Delhi Crimes 2, even today, movies are shot on these things, that even today, some ASI, as shown in the Delhi Crime 2 series, he is prejudiced against people living in the area, that they would have committed the crime, drag them to court. If any murder has happened, if any pickpocketing, any snatching has happened, it is likely the members of community living in the Pandav Nagar area. This is the predilection, this is the prejudice of the police even to this date. Okay, and that is why what in independent India are we doing? We are, instead of notifying them, we are denotifying them. So community 1, community 2, community 3, whose names were there in this notification promulgated or issued during the British era, their names are now being deleted, right? in order for us to delete these names, all of them, we need the enumeration. For enumeration to happen, we need to first find them out. That is why on the directive of the Supreme Court only, all these denotified tribes were to be identified. That is why the Government of India, the Ministry of Social Justice, they constituted a committee under Anthropological Survey of India and Tribal Research Institution to comprehensively categorize and find out all the denotified tribal communities, all the notified tribal communities, so that all of them are denotified as non-criminals, as members of the civil society. No prejudgment against them. Got it? So this was the problem. Now, what do we mean by semi-nomadic? Nomadic means tribes who will practice shift cultivation or felling of the trees in one area and then they will move to another area. Or nomadic tribes mean people who stay in winters in one area, and when the summer comes, they along with their grazing animals, etc., move to another place. So nomadic tribes, etc., they were also known for notorious activities. They will give effect to the crime in one area and then they will move to another area so that they are not caught or identified. Now all these tribes are sought to be denotified. This is the text or context of this particular news article. Now let's move further. Denotified tribes, everything has been explained to you. Just go through the PDF will be shared on the Telegram channel, as I said. Okay, now recommendations of Anthropological Survey of India and Tribal Research Institute. The study also found that 63 communities that had never been classified were not traceable anymore. Okay, out of these 268, 63 communities, denotified tribal communities, were such that they are not traceable at all. Either they have mingled up with the mainstream society and are living happily with them, or they have become extinct because of their very less number. Okay, so this could be the case. Now denotified, the Vimukta Jati. In Hindi they are known as Vimukta Jati. Just one more word we have added to it. Okay, why was the study needed? The Criminal Tribes Act of 1924, 1871, they were repealed in August 1949, after which the communities notified as criminal had been denotified. Now, what are the committees appointed on this matter? Lokur Committee 1965, Mandal Commission 1980, Renke Commission 2008, Idate Commission 2017. Idate Commission's report had noted that previous commissions had never been able to classify these communities. Okay, now lastly, please don't confuse these denotified tribes with particularly vulnerable tribal groups. Particularly vulnerable tribal groups are never found to be indulging in any kind of crime habitually or as a matter of pattern. Okay, they are vulnerable because of their lesser number, they are very few in number, and they are neglected. They do not adopt the allopathic medicine or modern medicinal practices, and because of some epidemic, etc., in their area, their number is further reducing. So that is why they are particularly vulnerable. For this Virginus Khaka committee, we will study someday, like we have studied these committees with regard to denotified tribes. Question can be asked in prelims that which all committees have been appointed to study the matters of denotified tribes. So here are the names of these committees. Now moving further, what is the need for categorization? Parliamentary Standing Committee on Social Justice and Empowerment had in December 2022 a report flagged the government's inability to take necessary action to ameliorate the conditions of these denotified tribes, okay, on the speedy categorization. So after the reprimand by the Parliament Standing Committee also, locating them required Anthropological Survey of India and Tribal Research Institute to come together to actually classify them, enumerate them as to how many of them are there. Only then we would be able to take some positive action. Okay, sensitization of, now what will be the next step? Sensitization of police, sensitization of judges, that these communities which were earlier classified as criminal have now been denotified. So do not unnecessarily persecute them. Do not make them the victim of any crime in the area. Police, in the rush to solve the crime, okay, they drag the members of these communities and label them as habitual offenders. Okay, so that kind of a thing should not happen to them. Now, UPSC previous year question, with reference to the denotified nomadic tribes, consider the following statements. All nomadic tribes are not DNTs, but all DNTs are nomadic tribes. Librhan Commission is constituted to identify DNT communities and prepare state-wise list of different castes of DNTs. So these are the types of questions that could be expected. Vimukti Divas or Liberation Day celebrated among denotified nomadic tribes. Moving further quickly. Okay, the denotified tribes communities are the most vulnerable and deprived communities. Mains question, discuss the issues faced by these communities and suggestions put forward by various commissions for their upliftment, for their welfare. Just allow me a minute. Okay, so these things are there. Supreme Court's journey reflects evolution in the rights and research and reach. So Supreme Court's journey, CJI of India at a function has highlighted the three challenges before the Supreme Court. What are these three challenges? Delay. Okay, that is the weight of areas which continues to delay justice. Second ARC on this matter had said, second ARC had once in 2008 report said in one of the reports that justice delayed is justice denied is an old adage or proverb. What is happening is, if there is delay in meting out justice, it is leading to criminalization of societies. Why? Broken window syndrome. The term it used, let me enlighten you with this term, broken window syndrome. What do we mean by this? It means that if you shatter one of the glasses of the window pane in an isolated building, let's assume there is a building which is lying dilapidated with glasses intact. If one child picks up a stone and smashes it at the glass, one glass breaks. Looking at the fact that nobody is reacting from the inside the building, there is no one to shout at that child, other children also copy him. They all pick up the stone and start yelling the stones or start throwing the stones at the building. Over a period of time, it is an ugly pattern that all the glasses of the window panes are shattered. This is what happens if there is one Sachin Tendulkar smashing the ball at the glass of the window pane. There will be many Sachin Tendulkars in the area. While all of them may not land at Wankhede Stadium, but window glasses of the entire building would be broken over a period of time. This is what leads to, this is how judicial delay, the meting out of justice, gives power to the criminal element. Criminal elements, they feel that, what do criminal elements feel? Let me give you an example. Criminal elements, they feel that they are going to go scot-free, they are not going to be punished for until 10 years, 5 years. Tariq pe tariq, tariq pe tariq, date on date. Sunny Deol's famous dialogue, right? So now what happens at the street level, if you are standing at the red signal, okay, you are standing here at the red signal, right? This is the Rajendra Nagar area and these are traffic lights, let's say. If one scooty guy, okay, he jumps the red signal, okay, looking at him, the Tata Nano also jumps the red signal because there is no cop standing over here. Over a period of time, you see after this Nano, there will be a big sedan crossing the signal. One after the other, you see signal is still red and nobody is stopping at the red signal. Even the big lorry, the truck, the tipper, everything is just looking at the red light, looking here and there and jumping the signal. This is the culture of lawlessness, which further feeds into the problem of pendency of cases. If the cases are not dealt in a swift manner, people think that let's clog the system. System is already clogged with, let's flush the system with more cases so that it becomes choked completely. This is what our Honorable CJI is highlighting through a simple point pendency. This is very true, okay? Then you see a girl on her scooty jumping the signal. Why should boys have all the fun? On a lighter note, right? So everybody starts jumping the signal, leading to traffic cop, if at all he comes at a later stage, saving his own life and swiveling through the vehicles, saving his own steps through the vehicles. He would stand as a mute spectator. This is what is happening in the country also, right? So this gives them the power. The criminal elements, they get the power that already 3 cases are pending and he is still out on bail, or he is still out because the next date is on after 4 months or 5 months or 6 months. He will commit another crime. Okay, looking at him, these people start appearing in the legislatures as criminal tainted MPs, and they become role models when they go on a Republic Day and give speech to the people, the budding children, the school children, that see, hamara neta kaisa ho, is criminal jaisa ho. In English, how should our netas, how should our ministers look like? Like these criminal elements. Now moving further, got it? Evolving role of Supreme Court, beginning of evolution with the strengthening. Second point, accessibility. Mounting costs of litigation threatens the true accessibility. Let me explain this. We came across the term senior advocate at least thrice in this news analysis today. Hardly been 45 minutes. We have talked about this senior advocate term 3 times. Advocate on record. These are the elite tags that every budding lawyer in his 20s or 30s would want to have. Senior advocate's fee of appearing, if I have a case pending in the Delhi High Court, for example, senior advocate's fee would be 20,000 rupees per hearing. He will just appear in the court, having studied the matter thoroughly. It will take him his time, legal acumen, legal application of mind, etc. But 20,000 is the bare minimum, I'm telling you. Senior advocates charge somewhere to the effect of 1 lakh per day, 2 lakh rupees per day. Can't this be done away by the Supreme Court? Why can't there be many senior advocates? Why not make the justice accessible? Reason is the hold of the Bar Council of India, Bar Council of Delhi High Court. They don't want this to be diluted. Okay, so this is how accessibility is a problem. You have to have a lawyer in order to plead before the court, in order to file a case in the court. Third, falsehood. Most fundamentally challenges, justice cannot thrive where and when falsehood is practiced. Okay, falsehood in the system is there in the sense that electoral bonds, criminal elements, fudging records, advocates hand in glove with the system, knowing that they are pleading for a liar. Okay, falsehood, the culture of falsehood in the country. Okay, so this is what CGI is highlighting at. Now, expansion of fundamental rights, the role played by Supreme Court in evolution of fundamental rights, specifically, or in ameliorating the conditions of women, downtrodden sections of society. Okay, empowering the citizens against the government. These are the themes around which you can expect a question in the UPSC or any state PCS exam, guys. So what are the themes? A role of Supreme Court in, reinterpreting the fundamental rights in the broadest sense, inventing new rights in its light. Right to privacy, 2017, adultery, then euthanasia, so many things. Okay, then LGBT community, transgenders, surrogacy. You see, so much of expansion in the fundamental rights part 3. Then giving effect to directive principles of state policy. Whenever these type of statements by CJI or UPSC chairperson or Prime Minister of India are made, we need to go into the depth of them, because they are the question material. The UPSC question material sometimes is highlighted. Okay, 3 challenges to judiciary according to CJI. But what are the 3 challenges according to you? Can be a question in UPSC mains or interview. Moving further quickly. Okay, recognition of emerging rights. Emerging rights, transgenders, LGBTQ, disabled people's rights. Okay, vague restrictions on online speech, section 66A, single case, right? So those things we are extending constitutional safeguards to digital spaces. Constitutional safeguards are being extended to digital spaces. Again, section 66A here. Socio-economic, it broadened the affirmative action to include economic criteria, recognizing diverse forms of disadvantages. Ram Singh judgment, in which this economic criteria is being talked about. Jats in Haryana were given reservation just before 2021 2014 railway, Rajya Lok Sabha elections by Congress government, the UPA government. Supreme Court said that rather than giving caste-based reservation to relatively empowered sections, it would be better to move beyond the caste-based criteria. Ram Singh judgment of 2014, and talk about economic criteria. That is what led the government to come up with the criteria of economically weaker section based reservation. The Supreme Court has been the trigger behind environmental cleanliness. Delhi Metro that you see plying in Delhi today is the result of the Supreme Court judgment. Otherwise, the then Congress government or any government of Sheila Dikshit or others would not have mustered the courage to acquire property, to demolish the road, big showrooms on the Pusa Road and elsewhere, and come up with the idea of metro. So Supreme Court has given the spine to the government, to courage to the government, so that government can do some good work. Strengthened economic landscape. So these are the points you can read. Landmark judgments: Keshwananda Bharti, Mumbai Kamgar Sabha, then SP Gupta, then Indira Gandhi, then Bandhuwa Mukti Morcha, then Menaka Gandhi, Union of India. These are the previous year questions. Examine the scope of fundamental rights in the light of the latest judgment of the Supreme Court on right to privacy. Practice question for today: bring out the role of judicial review. What do you understand by judicial review? Keshwananda Bharti judgment, okay, in safeguarding the fundamental rights enshrined in Indian Constitution. So these are the things here. Now moving further, ASER survey: reading, math skills improve across the states. What explains these gains? Now, national education policy can be said to be the first explanation behind these gains, and these improvements are being observed in the government schools. Okay, latest annual survey of education report brought out by Pratham, an NGO working in the education of children, or who brings the NGO which brings out this survey. Okay, they surveyed around 6,50,000 odd students across 605 rural districts. So you should be knowing focus is on rural. Many a times the question has been asked on this particular issue. ASER 2024 is based on a rural household survey conducted by NGO named as Pratham. Okay, so largely improvement has been observed largely in the government schools. Now, findings of the report: the number of class 3 children who can read a class 2 textbook in the government school stands at class 3 children who can read class 2 textbook. This is how ASER conducts the survey. If anybody has passed out of class 2, then only he's been promoted to class 3. And if a chap in class 3, if a child in class 3 is unable to read class 2 book, what is he doing in class 3? Okay, so only 23.4%, but still it is commendable when given the fact that in 2022 it is a biennial survey. It comes once in 2 years. Okay, so in 2022 it was 16%, now it has climbed up to 23%. So this is a good thing. Okay, in 2 years we have done this thing, and our national education policy came in 2020, so it could be credited to national education policy only. Basic arithmetic levels: the report says that they've approved from the pre-pandemic year of 2018 from 28% class 3 students who could at least do a simple subtraction sum that year to 34% approximately. Okay, so simple arithmetic, subtraction, addition, this number has improved by around 7 points, 7 percentage points, from 28% to 34%, 6 percentage points you can say. Okay, then almost all the states except Jammu and Kashmir and Nagaland have shown a recovery in the leading learning levels of class 3 students when compared to 2022. Top performers: Haryana, Himachal Pradesh, Uttarakhand, Maharashtra, Uttar Pradesh and Odisha. So they have showed 10 percentage point increase in the reading levels. How can we use this? Now let us talk about the application. This report gives you enough data, and it is a bipartisan report since it is not by government agency or think tank, government sponsored study like Niti Aayog, etc. This study is by an independent NGO with a lot of credibility, Pratham NGO, right? So when writing any answer on child education or on national education policy, its performance across 4 years now, national education policy has been there for now 4 years. You can use the findings of this survey that Most signs point to the national education policy and its focus on foundational skills. Foundational skills. So, while writing any answer, to substantiate your argument in favor that yes, the schooling in government education, government schools is improving, education level or standard of education in the government schools is improving, or writing any answer on right to education. Okay, so you can use this data in your answer so as to substantiate your point. That's the only advantage. Can this be asked in prelims? Yes. Question around Pratham NGO ASER survey has been asked in the UPSC 2012 or 13 examination, current affairs, okay, section. You can check it out. I'll share the question on the Telegram otherwise. Now consider the following statements about ASER conducted by Pratham. So this is the question. Okay, now what's on the agenda of the Paris AI summit, where PM Modi is the co-chair, amid growing concerns over how to develop regulatory oversight of artificial intelligence without stifling the AI ecosystem. Now the challenge before world is, we want to adopt the child called AI, baby of AI, which is growing bigger than father, the technology itself. Okay, so but we don't want to stifle it, one, but yet at the same time we want to keep it under check so that the advantages of AI should not be less than the disadvantages, or disadvantages should not far outweigh the advantages. AI might lead to some scams, technology being faked, or technology being used in a disadvantageous manner. Okay, AI failures. Then AI is skewed in favor of 4 or 5 big companies, Meta, Google, these big companies, Microsoft. They are, because of their relative technological advantage, because they are at an advanced stage, so they are in a way siphoning off the undue gains of AI rally, the new trend that is coming. Okay, so AI safety summit that is being held in Britain in Bletchley Park in 2023, that was held, and now this smaller meeting in Seoul was held in 2024. This meeting is going to be held in France, right? Paris AI summit. The Paris summit is an initiative of the French president. Focus agenda for global AI governance. How to globally govern AI. We have global norms for governance of internet, .com, etc. Okay, how these internet names are allocated, there are norms for it. But are there any norms for AI? Many cases are being filed by AI, filed against AI companies like ChatGPT, etc., that they are floating on, ChatGPT is floating on the content produced by news portals, online news portals, Hindu newspaper, Times Now Group, Times of India Group. They are filing cases. Now, what is the aim of this AI governance summit? To address the increasing concentration of power in the AI market, concentration of power in the hands of a very few companies, Microsoft, Alphabet is the company behind ChatGPT, Amazon and Meta, right? So why this power is concentrated in the hands of a few? Sorry, Alphabet is Google, right? Now these things are there. Moving further, AI regulatory authority, we need to establish a law, monitor enforcement of that law at the global level. At a time when there is no credibility for United Nations, at a time when Donald Trump is saying that he is going to withdraw support from WHO, world is in a disorder, we have come up with a new baby to be managed, and that baby could be very dangerous. The name of the baby is artificial intelligence, right? Coordinating and standard setting, facilitate global dialogue. There have to be international institutions of credibility. We need to start from the scratch because this is a new area. There are no norms. Then innovation and compliance, ethical AI development. Ethicality in AI is a big issue, right? Deep fake, etc. Those things are happening now. Advocacy and ethical oversight, public engagement, civil societies need to play their role, but civil societies themselves are groping in the dark. This is a new area. States, the governments and the national governments, okay, they have to enact a legislation and implement the legislation. Then they have to collaborate at the international level. So these are the challenges. Okay, AI and the global governance challenge. So no universally accepted definition, difficult to establish consistent regulations because there is no definition. Technological pace, geopolitical competition, these are the points that you can quickly read No rocket science involved in that. Okay. So guys, this was all in today's news analysis. See you again tomorrow in the next class. The questions, etc., they have been incorporated in the PPT. We are today skipping out on one of the topics. I would have wanted to explain this, but this will be the next. This will be the topic to be dealt with in the next class. Rest assured, I'll deal with this topic, but we have to be in the time limit also. So I'm stopping it here. PYQs, etc., you can refer to at the last. Okay, these are the answers for 28th of January. Since many of you are not attempting the questions, I feel like not incorporating them or not at least reading them out in the class. The more the interest, the more the engagement, the better it would be. Lastly, please answer quickly. Those of you who are writing prelims in 2025, please mention in the comment section. Or those of you who are writing in 2026, aiming 2026, please mention in the comment section. And prelims 2025 students, do you want us to start some MCQ series on this channel, 10 MCQs daily for polity or current affairs, or both of them? Or you want 10 tests to be organized at PW only IS English, wherein I'll be taking the discussion, etc. There will be a mock test kind of an arrangement wherein you can attempt the mock test on the website, and we can have the discussion after 2 days or the same day when the test happens. This is for prelims 2025 students. Okay. PDF of 25th January has been deleted by mistake. I saw your comment but could not help you. I'm sorry about that. Still try to recover it from somewhere. Okay. Else I suggest you to quickly take the screenshots of the this lecture 25th January if you genuinely really want it, and then club them up into the PDF. So this was all. Thank you guys. Bye bye. See you tomorrow. Do give your opinion on this thing, whether you want the prelims 2025 10 or 15 tests to be conducted under Udan series itself. Thank you. Bye bye. Thank you guys.